All right. So I have a packet that was provided to me, I think, a day or so ago. So I always just like to take it from the top, even though a lot of these aren't disputed. It just keeps me in order here. So if we just do that and everybody just grab the packet they have, and on top of it should be preliminary instruction.
Yes, sir.
Although I asked for it to be included, I won't read that again because I've read it already once. So, but I like it in the packet just because I promised the jurors I give it to them. So preliminary instruction, and it looks accurate. And note-taking by jurors. I will not read that again. And we'll get right to the meat of it now, which is introduction to the final instructions. Obviously standard and statement of the charge. Now, I have 1, manslaughter while armed, and 2, attempted first-degree murder with a firearm.
Yes, sir.
Well, I have manslaughter by culpable negligence.
Okay?
These are the final instructions that I sent on Monday.
Okay, so you've updated and elected to go with manslaughter while armed. Correct? That's the heading? That's correct?
Yes, sir.
You got what you need there?
Yes.
Okay. All right. And then the very next instruction is when there are lesser included crimes. So the first part of what we know is standard. And in this case, the lesser crimes indicated in the definition of manslaughter while armed is 1, manslaughter, 2, culpable negligence.
Yes, sir.
Defense?
Yes.
Okay. And this is the requested lessers, and everybody's satisfied?
Yes, sir.
On the manslaughter, yes.
Yes. Then, the lesser crimes indicated in the definition of attempted first-degree murder with a firearm is attempted second-degree murder with a firearm. State, that's a standard lesser,
Yes, sir.
and that's what you want.
Yes, sir.
I got a feeling defense is going to say something else.
We do object.
You object?
Yes, sir.
Okay.
I understand that it's.
So you're just preserving?
Yes, sir.
No problem at all. I just want to make sure we're on the same page. So the objection's overruled. I think the law says they're entitled to it. So the next instruction I have is introduction to homicide.
Your Honor, we had submitted requested jury instructions. We filed them on March 4th. That's requested instruction, introduction, final instruction, and justifiable use of deadly force. And we had asked for assault as a lesser of attempted first-degree murder.
All right, so back me up. We're back onto the page I just covered. So
Well, yes, because we.
it's no problem. Everybody relax. We're slowed down. We don't have a jury here. Relax. So when I was on when there are lesser included crimes, so the lesser crimes indicated in the definition of attempted first-degree murder with a firearm is attempted second-degree murder with a firearm. You objected. I overruled it. Now, do you want another lesser?
Yes, and we had requested it in writing.
It-
It is assault.
You want assault?
Yes, sir.
What do you say? State. Legal objection, not whether you like it or not.
There's a lot more lesser included between attempted second-degree murder and misdemeanor assault.
Okay. So, talk to me. I'm here to, they've asked for assault. I think legally they be entitled to it. Am I right, guys?
Yeah, I mean, it's a category 2 lesser, yes.
And that the state, I would imagine, could be entitled to aggravated assault with a firearm, correct? And,
Yes, sir.
well, you guys tell me what you want.
We could request aggravated assault with a firearm if the defense is requesting assault.
Okay. And defense, that seems logical.
Well,
Not whether you like it, and I don't mean that in a rude way. I'm trying to be really focused on who's objecting, legal objection, and whether it's a preservation objection or you have some real legal basis and you want to argue about it. So you're asked for assault. I don't think they can stop you, and I think I'll give it. And then based on that, they say they want aggravated assault with a firearm, and I think that would be, they would be entitled to that as well.
This is an I don't like. This is an I don't like.
Okay. Perfectly fine. So, aggravated assault with a firearm. In regards to that count, does anybody want anything else? Without hearing anything, please fix that to reflect aggravated assault with a firearm and assault. All right, let's move on. Introduction to homicide. Now, the first part of it is standard, then justifiable homicide. It looks like the standard instruction, right?
Yes, sir.
And then excusable homicide. And that's all standard. Would everybody agree with that? So I can flip the page?
Yes, sir.
Defense?
Yes.
All right, now we'll get to the justifiable use of deadly force. Now, the one that's in the packet is the standard instruction, am I correct?
It is, I believe it took out threaten to use language.
And direct me which paragraph. I think you're talking about 1, 2, 3, 4, 5, 6, which starts with however. However, if an officer uses excessive force to make an arrest, then a person is justified in the use or threatens use of reasonable force. Mr. Richardson, while they're looking over there, did you give me a different justifiable use of deadly force instruction?
So yeah, Nouman Raja was justified in using deadly force or threatening to use deadly force. So that would be where it begins. So we're looking at 3.6F as in Foxtrot.
Can you pull it up? Can you print it? Or you can't print from here? Okay. Oh, email it to me, and I can print it.
So the two spots would be that paragraph starting with Nouman Raja was justified in using or threatening to use deadly force. And then also the next one would be on the top of the second page, however, the use of deadly force is not justified if you find that Nouman Raja used force or threatened the use of force.
State, have you seen the defenses?
Yes, Your Honor, we've seen a copy of the justifiable use of deadly force with Lyons' objections shown by strikeouts. I'm assuming that's what we're seeing.
That's what we said, yes. And what we submitted, Your Honor, on the 4th was...
Oh, you're giving me the standard. What I'm asking you is, they filed one with the court, and do you have access to it? Damien, just relax. Damien, could you go on the court record? And they've said they filed something on March 4th regarding jury instruction. Could you print it for me?
It's called Notice of Filing, and then it has 3 paragraphs.
Okay.
And the instructions are after that.
I emailed mine, actually, I believe I emailed mine
I've got,
Saturday. It would have been either Friday or Saturday.
I want to make sure I'm working off I'm working off the packet I got from the state right now.
That would have been just, I can tell you exactly when I emailed it to you, so I guess.
You don't have access to the court. Oh, on the laptop. As sure as the law I'm printing.
36 pages.
It's 36 pages?
No. The justifiable use of the entire request is 36 pages because it incorporates what the defense
Okay.
state had. Our justifiable use of deadly force is 3 to 4 pages.
Mine would have been sent Saturday, Your Honor, at 12:30 p.m. that I had sent. I have a copy of the defense's.
Thank you. See, normally how I do this is I literally come and sit with the lawyer so they can look over my shoulder, and instead of saying I'm working off this or that, we actually can look at it together. So I'm going to do that because saying you sent me something, it's hard for me. Where's Jeffy Dunn? You do me a favor. You move that podium right there. He's got big biceps. I know if I try to move that thing, I'm going to get hurt. Thanks. I have a bad shoulder. Thanks. Now I'll stand. If I get the lawyers, just when we have an issue, you just come stand over my shoulder right now, please. Yes, ma'am. I'll just talk up. So, if I get the lawyers come stand over my shoulder literally right now. And is this the one that
Yes.
should be worked? So
Yes, sir.
That's accurate. This is the one you want me to work off of?
Yes, sir.
Okay. Now, you have sent me a different version, correct? All right. And am I looking at it? This is it right here.
That's one requested instruction.
So now, where would you want that?
It would follow this. There, in other words,
You mean a separate instruction?
Correct.
Okay. This is the statute, right?
77601.
Okay.
With some change, with some.
So I want to know about the modifications. All right, so this is the statute. This is what was in play in Peraza. Am I right? Okay.
Very specifically, because they found that he was in the execution of a lawful arrest, yes.
So that's what I'm going to talk. So I didn't know if this was coming up or not. And
And they even more specifically said, but for that, he wouldn't have gotten this too.
but I noticed in your instructions statement that you have this paragraph still in there. However, if an officer uses excessive force to make an arrest, so you're arguing this is not an arrest, correct?
Correct, we are.
That's
We are
what confused me
arguing
then.
But that should come out.
From your opinion, that should come out. In
Yes.
fact, they have a different
But that should
opinion.
also be, I'm sorry, I don't want to, sorry.
You're perfectly
But that, this one is not included, the one regarding justifiable use of force by law enforcement officer. It's our position that this instruction would be improper because I don't believe there's any evidence that the defendant was making
So I included that because it was part of the standard instruction, not because we necessarily want it, but because it was part of the standard instruction. The only change I made was that two parts that took out threat use of force because he actually used force.
Okay. All right. So now speak up loud enough for Madam Court Reporter. So you're asking for the 776 instruction. Now it was referenced in Peraza, correct?
Yes.
How do you get around? Now, I know in Peraza they say one of the things that they found the stand your ground was applicable, that a law enforcement officer is a law enforcement officer 24 hours a day, 7 days a week. Right? And it's been a couple of weeks since I read Peraza, but
I provided copies of
I
both
have
cases.
I have it sitting right up there. So my question to you, and I thought that this from the very start, when I started researching the issue about experts and my ruling a while ago about the expert testimony regarding police practices and things of that sort. Tell me and direct me in Peraza or any other case that would make that applicable when, because there's, would you agree, if we get our argument teed up correctly, would you agree in this case there's no evidence that he was in the act of making an arrest?
For the footnote that we have in our requested instruction quotes from Peraza, which talks about.
Well, let's back up for 1 second. I guess I am interrupting you, but my question, but we'll start with the first part though. Nobody's arguing that in this case, as it was occurring, that he was making an arrest.
Not in the traditional sense.
All right. So now you want to direct me to Peraza why you would still think you would be entitled to this instruction.
Yes, sir. And that's in footnote 1 at the bottom of this requested instruction, which talks about shouting commands. It says, as the circuit court found, after the officer and the sergeant spotted the man about 20 yards from them, both the officer and the sergeant shouted the command, "Stop, police," and dropped the weapon. The officer then closed his distance from the man to approximately 5 to 10 feet and continued to command the man to stop and drop the weapon. It is reasonable to conclude that the officer was taking these actions to make an arrest and not merely to investigate the man's intentions. So that's why, and I've highlighted the areas that we wanted added, but is the second paragraph that we are using to, based upon the
Just 1 second. And I would focus your attention, though, to the last sentence of the quote in Peraza. It is reasonable to conclude that the officer was taking these actions in Peraza to make an arrest and not merely to investigate the man's intentions. Isn't that what was happening in this case?
Are you asking the state?
No, I'm asking the defense. Isn't that, at this juncture, what we knew at that time, why is this abandoned car there? Go ahead.
But that changes when Mr. Jones pulls a gun. At that moment, he's no longer investigating the abandoned car. Mr. Jones has actually committed an aggravated assault on him. And therefore, you can reasonably assume that he pulled his gun and to, in effect, an arrest.
State, give you your opportunity to talk to me.
In the Peraza case, Your Honor, they did not in any way expand the scope of this defense to include situations where somebody is not making an arrest. The facts in this case, in Peraza, were a little bit different. If I recall, the victim was walking around with a firearm, and that was the call that prompted the police to go there, not a broken down car. The facts are distinguishable. Peraza does not make a blanket holding that arrest can be shown just by an officer shouting commands, stop, situations like that. It doesn't hold that. The language, the plain language of not only the standard instruction, but also the statute on which it is based makes it clear it's limited to where a defendant is attempting arrest, a law enforcement officer is attempting arrest.
Defense, I think I heard you say that you had another case as well.
Peraza 1 and 2, the fourth DCA case and the Supreme Court case. The Supreme Court case doesn't specifically address this issue, but it affirms the fourth DCA.
And in Peraza, Your Honor, the whole point of law enforcement arriving on scene was to investigate a crime and potentially effect an arrest. If we read this ruling to say that every single time somebody threatens to use force against a law enforcement officer that they get this instruction, then that would mean regardless of what any officer does at any time, when anybody defends themselves against an officer, they get this instruction. And that's not what Peraza says. They actually have to legitimately be responding. The word drop by the defendant in this case is really, it's intrinsically intertwined to the response of Corey Jones. It's not something that where he is going there to effect an arrest and then now there is some type of threatened use of force.
Judge, that.
All right, hold on a second,
Okay.
please. Sorry.
No problem.
Does anybody have the standard, the actual instruction, or it's a statute?
It's a statute.
Does anybody have a hand?
There's both, it's like here.
You have it? Can I see it, please?
It's 776.05, right down here.
Thank you. All right, so let's talk through it a little bit more. I got reversed in a first-degree murder case. The jury instructions are tricky, and where I let some evidence in, I made the proper ruling when the defense asked for a jury instruction on it. I said, no, I'm going to stick with the standards, and I got reversed on that. And so I've really tried to slow down when I'm doing this process because they will nitpick everything I do right now. My question, so if I was to read the actual instruction, wouldn't it really, so in my fear of not giving an instruction the defense requested, really, as I'm thinking about it, I'm going to let you respond to help me work my way through it. The jury can make that determination. So if I read the instruction, there are lots of instructions that you read, and in the alternative, you say to the jury, if I was the state, where's my instruction? Thank you. Of course.
The instruction number is 3.6D. All right? Based upon 77605.
It's 3.6H.
Oh,
H.
sorry. Sorry.
Somebody else.
We all got our glasses in.
Glasses, I can't see that.
It's all right. What I'm saying to the state now, if I read the instruction, a law enforcement officer or any person been summoned or directed to assist need not retreat from or stop efforts to make a lawful arrest. And the state's going to submit to you in this case, you'll make the decision. There was no arrest going on here.
Well, he was not summoned or directed either.
I understand. I'm trying to find some.
Yes, sir.
Because I don't like the language you've written in. So if I'm going to do it, I would read the standard instruction. You're actually adding some language to it, and I'm trying to analyze this. And so let me tell you what I'm thinking and give you a chance to say, don't do it. and I'll give you a chance then to respond why you want it your way. My thought is to read the standard instruction, but not read it as they've written it here with that language about if I tell you stop, drop, or similar commands. I'm not going to read that.
I'm interested in what the court considers a standard instruction, because this first part here is in making an arrest of a felon. And that's not what's happening. That's not what the evidence is showing.
I disagree. I think that's totally what's happening.
Okay, hang on.
So I'm interested in which part, because there are different parts, of course.
Let's see.
We've got force.
But what,
Obviously wouldn't prevent escape, custody. And that's specifically why the state doesn't think that this is an
it's
appropriate.
interesting how they put this in italics here, but it's never, let me see. It's not mentioned inside the instruction. You see what I'm saying? It's in italics, saying we're relying on 776.05, but it never says, it just says in making an arrest, not a felony arrest.
Well, that's I mean, this entire bold section is the entire instruction, so
This is
this
in-
necessarily is included. That force is also justifiable when necessarily used,
But it's in
colon.
I'm sorry. It's in addition to these other things. In retaking a felon, he's not committing a felony, but he's escaped. In arresting a felon as fleeing from justice. So I would take those out. That doesn't apply. You would stop there. You understand what I'm saying?
Yes.
And that's interesting that that's there, but it never says it in the body of the instruction. Let me ask you this. So I see a guy committed a battery, and I'm there trying to arrest him, and he punched his wife in the face. That instruction would apply, even though it's not a felony.
I'm not sure how it would apply once
I-
he actually commits some type of offense against the law enforcement officer, in
Right.
which the officer was not the initial aggressor, then yes.
But the fact that it's a misdemeanor doesn't change anything. I think there's italics. Does anybody have a case that says it has to be a felony as opposed to a misdemeanor? It just says arrest,
And
right? It just says arrest.
since it pretty much parrots 77605, I think that the jury instructions committee put that in there, maybe it was editorialization, but the statute is entitled Law Enforcement Officers' Use of Force in Making an Arrest,
An arrest.
not a felony arrest.
And this is kind of a new area here in regards to the Peraza case. Okay, my law clerk has something. Yep, that's the italics.
One second, Your Honor.
Yep. You wanted to tell me something else, because something else has jumped into my thought process, so
Go, if you want to go ahead first, Your Honor, then I have something to solve the issue, but.
tell me.
What the court said earlier about our ability to explain to the jury that this is inapplicable is very true. We don't think that it applies because the facts aren't there to actually support that he was directed or summoned there in order to do any type of action. But if we're looking at limiting the instruction to specifically that small part, not what the defense is asking for at all,
No, I'm not going to read it.
but just that small paragraph of the standard instruction, which talks about if he were summoned or directed, this is the type of self-defense by a law enforcement officer that would be applicable to him.
Are you referring to this?
I'm referring to, can you just hand me that book, please? I'm referring specifically to, and I'll refer to this because I don't want to get into what they had written. Right here, specifically under 3.6H, just this paragraph minus 1, 2 that stops.
That's
If we're talking about specifically that,
You can write on that.
and that is something that everybody's agreeable to,
Starting with what?
starting here. And that one. That's it right there, right?
yes, sir,
Am I tracking that correctly?
you are, yes.
Law enforcement officer, any, we don't need or any person. Need not,
Well, we do need,
nobody was summoned or directed to
Okay,
assist them.
gotcha.
Need not retreat from. So you changed the note to make it.
There's just, when you're reading it, it is, need not stop efforts to make a lawful arrest. He's not there to make a lawful arrest at all. And the threatened, the self-defense that was put forward by Corey Jones is only because of the initial aggressive actions of the defendant. So
I'm sorry, that's looking at the eyes of Corey Jones, and you can't do that. And so what we're talking about here is, it doesn't matter whether he was summoned or directed, because if an officer walked up on someone just by walking down the street and the person came at them, he's justifiably allowed to defend himself. And that's what that's what that gives him. You can't limit it to directed or summoned. Police officers engage people every single day for very different reasons. It happens. And what you're saying is if an officer approaches someone and that person somehow attacks him because he wasn't summoned or directed, he can't defend himself, and that's just not right.
Well, on the same vein, I don't think anybody's mentioned that there's superfluous language in here in the first paragraph
we're definitely not going to,
where it says stop efforts to make a lawful arrest or carry out any other execution of a legal duty. That's not part of the standard instruction. I'm not sure if there's any law to support that.
but nobody is saying a law enforcement officer cannot defend himself if somebody just walks up to him on the street and attacks him. What we're saying is a law enforcement officer can't go up to a citizen, punch that citizen in the face, and then get this instruction whenever he then attacks the citizen.
I didn't see that in the case.
And when the citizen attacks him, he doesn't get the instruction.
And everybody pause. Madam Court Reporter has to tap out. We have a replacement, so nobody say anything right this second until they get set up. Give me Peraza. It's up there somewhere. Maybe underneath my book. Or underneath that, maybe. Anything further, Steve?
No, sir.
Defense. All right. So if you look at the footnote in the Peraza case, they specifically go out of their way to say, and let me just read into the record. The 4th District also found this case distinguishable from Camano based upon a secondary finding by the trial court that Deputy Peraza was not making an arrest when he shot McBean. This is legally significant because Section 776.05 immunity only applies when an officer is making an arrest. Because we have jurisdiction based upon the certified conflict and the certified question, we've elected to address the issue presented by the certified question, which renders the analysis of the distinguishing fact unnecessary, which means they placed importance on that but didn't reach it, meaning the trial court needs to make this analysis whether he's in the process of making an arrest. And if he's not, what the Peraza case is saying is that law enforcement officers 24/7, if they're making an arrest, are entitled to both forms and immunity. But this case, in my opinion, specifically says they have to be in the act of making an arrest. And and so I'm not going to read it. But further, that goes kind of hand in hand with my original decision, much to the state's chagrin, that I wasn't going to allow them to call an expert about police practices because it wasn't an arrest. That was part of my analysis. So, we've noted it for the record, we've preserved the issue, and boy, it makes me very nervous. So let me just turn to you one last time. With the proviso that I would only read the actual instruction as it is there, state, you get to decide after what I've just said, should I read it or not? Just the standard instruction. You get to pick.
Can I just have a second?
Of course you can.
No.
Okay.
And just to put it on the record, there has been no facts specifically through the uncontroverted phone call of the AT&T roadside assistance that the defendant was actually affecting an arrest at the time that the force was threatened to be used.
And that's my rule.
Thank you.
Okay. Now, I've made a mess of my packet. Ms. Miller, can I get you to take your book back? Now, so.
And then-
Go ahead.
I think
It's no problem at all.
Mr. King and I were just discussing what we have to do. We've made the objection on the record. We have to do it again at a later time, and then we have to do it again another, right?
And I want to make sure you get your record preserved. I don't try to block people. Some judges like to do that. I don't do it. I think we've teed it up, but you make your objections when you feel it proper, before I read the instructions and after I read them.
Yes, sir. We've made our objection on the record now as to the court's decision to not read that instruction, and we'll do it when we next need to.
I respect that.
Right.
Now, the instruction now that's in my packet, so I'm not going to read this instruction. I've circled this and I can't remember why.
Before we get there, paragraph starting with Nouman Raja was justified in using deadly force. And the standard instruction has brackets including, it says using or threatening to use deadly force. I elected to put using deadly force in there because that's the standard instruction and that's what was proved through the evidence. But I just want to make it clear that that was a choice on the standard instruction.
I'm a little confused.
Yeah, where you at, Brian, sir?
It was going to be, if you look, the 1, 2, 3, fourth paragraph, starting with Nouman Raja was justified in using. If you look under 3.6F, it's going to be down at the bottom of the page, justified in using or threatening to use deadly force if reasonably believed such force was necessary.
Do you understand what you did? And what your, and
Our requested instruction is to read standard with that bracketed language in.
I'm showing you the book.
Using deadly force or threatening to use?
Yes, sir.
Okay. Granted, fix it, please. It didn't come out right. All right, granted.
Yes, sir. That whole sentence has some additional language which we underlined as requested. I know this is confusing, Your Honor, but
That's why I'm standing down here, so we can all look at the same pages.
so what our request is that this be read.
Give me my jury instruction book.
This,
Thank you. Sure.
This is
Got me confused now.
Let's see, so we're going to be,
the book is different from this book. Your book is different from this book in the actual language, I think.
There's something
So-
not right. My book was just updated.
is justified in using deadly force Shall be using or threatening to use if reasonably believed.
Oh, you got to speak.
If reasonably believed such force is necessary to prevent imminent death or great bodily harm to himself. And then imminent commission of applicable forcible felony is not included.
Not included where? In the court's book, or?
No, in here.
Correct.
Correct.
It is included in ours.
Okay. Where did you get that from?
It's the standard instruction says it's necessary to prevent imminent death of great bodily harm to himself or the imminent commission of and the applicable forcible felony against himself or another.
And that's in the standard language, and you believe it applies.
Yes.
And the state, you're thinking it doesn't apply.
Correct.
I'm going to read it. So just put it in there, please,
The way that we drafted it, Your Honor?
as the standard instruction reads with the,
With the applicable
with your
felonies.
request.
Yes.
Correct. With the applicable felonies.
And then,
Oh, I didn't. Just one moment. Your
Yep,
Honor, please.
yep. See, I'm glad I excused the jury. It takes a long time. I just, you're frightened. So I'm not rushing.
Judge, what year is there instructions? Because I don't think it's mentioning a timeline.
What's that?
What year is there? Are there instructions? Is it most current?
Yes, sir.
so where are we?
So we're still on the justifiable use of deadly force,
Yes.
and we've now made our way down.
Right, and then the standard instruction then says, after you read the forcible felony, it says, give elements of the applicable forcible felony the defendant alleges the victim was about to commit, but omit any reference to burden of proof. So, because the court has already separately defined murder, attempted murder, or will, then it says the elements of aggravated assault are as follows. The first three elements define assault, and the fourth element is with a deadly weapon. So we're reading the attempted murder and the aggravated assault with a deadly weapon.
And you're saying, I don't have to read the murder twice because I'm already giving it.
Yes, sir. Correct.
Do you understand what we're saying?
Yes, sir.
Everybody's on the same page?
Yes, sir.
Yes. My only question would be whether we should also read attempted murder by rape also, even though it's,
That was a question you just asked.
right.
You just got, everybody's got to speak up a little bit. So,
We're fine with it being read somewhere else, sir.
Okay.
It's already read later in the
Okay.
instructions.
so everybody's happy that I have previously have read it. Okay. Anything else on this justifiable use of deadly force?
If the court would turn the page,
Or two?
now we have a paragraph that reads, immediately after defining aggravated assault, if the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Nouman Raja may be found to have been in fear, and actual fear on the part of Nouman Raja need not be shown. I think that is,
Where is that?
it's in our request.
It's not a standard.
Right.
Correct. It's immediately after the definition of the fourth element of aggravated assault.
So where was this pulled from?
This is language that sounds familiar to me from from an assault definition, I think, right?
It certainly looks familiar,
Right.
and I don't know why we would read it again there.
No, sir, I don't either.
You think it's familiar from the document?
No, somewhere else in here. Maybe the ag assault instruction?
Let me look there, see.
Well,
Okay, there's an element under aggravated assault, we have been created in the mind of both
Oh, slow down and speak up.
That's not, talking about this instruction right here. The circumstances.
Right.
That's going to be part of aggravated battery or assault.
but it will have, it will have previously been read as a lesser included offense against the defendant, but this is inserting it in the forcible felony section of self-defense.
And if we could go ahead and read it here, and then under the lesser included offense of aggravated assault with a firearm, we could say that instruction's previously been read to you, and then not have to reread it.
So you're agreeing to read it there?
That's fine, yeah, and then we just don't have to read it later. Under the lesser included, we could say you've previously been instructed as it relates to aggravated assault.
And because we don't have their aggravated assault instruction in this packet yet, because that just came up today, right?
Yes.
Correct.
Guess we need that.
Let's make sure what that says. Can we flip to it and make sure that has the language we're all thinking it says?
Well, maybe in the event that there is directly on the road, aggravated assault
And assault.
Murder, and murder. Then we say they've both been previously defined.
Yeah.
Or Deputy Hunter, we pull the mic through so that it's on the other side.
That is, the circumstances is part of the standard instruction for ag assault.
Okay, he's got the standard instruction there, says it includes it.
8.2.
Great, so I don't have to read it twice, guys?
Correct.
You prefer it in the justifiable use of deadly force instruction?
Yes.
Granted. Don't make me read it twice. Okay, what next?
I believe the however part that you had circled.
Yep. Now, based on my ruling, shouldn't that be out?
Yes, sir.
Based on my ruling, whether you agree with it or not?
Yes, based upon your ruling.
Okay.
we-
Out.
Our objection is noted.
Noted. Then we go,
Now,
This is the initial aggressor.
right. Now, did we skip over this language? Here it is, right there. Okay. Did we change anything? Now, the only, okay, yes, sir, we did. We inserted the name Nouman Raja. Oh, there it says,
you want his name in there, but after defendant,
however, the defendant Nouman Raja.
right
correct?
there.
Right. That sentence, in our request is that that sentence reads, however, the defendant Nouman Raja had no duty to retreat, period. Now, because the rest of it really isn't applicable, this language. If he was not otherwise engaged in criminal activity and was in a place where he had a right to be.
Stay.
It's really not applicable.
Not the standard, we got it included right up here too, in this paragraph about not engaged in criminal activity, not in a place he had a right to be. So, we believe he's assaulting Corey Jones, so we want that in.
And how about was in a place where he had a right to be? So, however, the defendant Nouman Raja had no duty to retreat if he was not otherwise engaged in criminal activity, period. Or do we have to have that end?
I believe it's an and, it's an inclusive, so yes, sir.
Okay. I'll read it. I'll read it in both places. Okay, now we go to the next page, right?
Right, this is where we have, this is the aggressor stat section.
All right.
Our position is it should not be read at all.
Your Honor, I have a case that I recently provided to the defense that says it should be removed.
And we have
It's the
cases as well.
Thompson case. Let me,
I've read that, fine. I got it. Are you giving it to the judge?
I need a copy. I think you may have given it to me. What's the name of the case?
It's Thompson v. State, 257 Southern 3rd, 570.
Here it is. But there are three cases, two from the defense and one from the state that we will be discussing.
And, Ms. Miller, can you direct me where specifically you want me to look?
On page 581, the case talks about how in altercation, when you're talking about the initial aggressor instruction, it can actually be two altercations in one. It can be two events that make up an altercation. So in that particular case in Thompson, the court found that the victim was the initial aggressor in the first occurrence, but then the defendant left the scene, came back with a sword, and stabbed the victim. And so he was the aggressor on the second part, which meant that the instruction was proper. The court said that the initial, and this is just about a quote, an initial aggressor instruction is proper where the defendant may have initially provoked the use of force against himself. I believe that there have been sufficient facts that would show that. Let's see, they also rely on a case called Which. It's cited in their WYCHE v. State, which says that you can have two events that make up the two different altercations with two different aggressors. So even if the court were to find that the victim was the initial aggressor, which that's certainly not our position, but if the court were to find that, then it could still find that the defendant was the aggressor on the second part of the incident. Does that make sense?
I think the analysis needs to begin before that, and it's in the Martinez case, which is the footnote 8 in our request. Which is 981 Southern 2nd, 449. Followed by, and I gave those cases to the clerk. And followed by the case of Gibbs versus State, which is at 789 Southern 2nd, 443. Those two, and what they stand, what these cases basically say, Your Honor, is that the simple use of the word provocation has to be more defined. So in the Martinez case, it says, it was talking about the use of paragraph, subsection 2 of the statute. 776.041, use of force by aggressor provides that a claim of self-defense is not available to a person who, 1, is attempting to commit, committing, or escaping after the commission of a forcible felony. 2, initially provokes the use of force against himself or herself unless, and then it goes on to talk about unless. But then it says, subsection 2 governs the circumstances where the defendant initiated the assault. You then need to look at, so you first have to determine whether or not Mr. Raja's actions in driving the wrong way, all the actions that we've talked about, as we talked about in the motion for judgment of acquittal, driving up the wrong way, parking his vehicle where he parked it, getting out of the vehicle, approaching Mr. Jones and not having his ID on, any of those constitute an assault. And whatever it is that he said in the conversation, are any of those an assault? They're not. And Gibbs, the Gibbs case, says, in this case, it was there was an objection to the giving of that instruction. It says, we agree with appellant that the jury instruction given by the trial court was inadequate to properly charge the jury in this case. The instruction stated that appellant could not defend herself with non-deadly force if she, quote, initially provoked, unquote, the victim. By not limiting provocation to the use or threat of force, the court failed to make the jury aware that the word provoked, as used in the instruction, did not refer to mere words or conduct without force. Stated another way, the instruction given by the court eliminated the use of non-deadly force in self-defense if there was any provocation by the defendant, no matter how slight or subjective the provocation. By that standard, a mere insult could be deemed sufficient to prohibit defending oneself from an attacker. So, our position is that this instruction is inappropriate to read because the definition of provoke has to include the use or threat of force. And none of the actions that Mr. Raja engaged in the light most favorable to the state, could be considered the use or threat of force.
Your Honor, the Gibbs case addressed the standard jury instruction is not in place anymore. The jury instruction that's in place now on the initial aggressor instruction includes the language that was omitted in Gibbs. So Gibbs really isn't relevant. We agree that the initial aggressor instruction needs to include the threat or use of threatening. I'll read it exactly as the standard instruction said.
So at the top, it say, however, the use or threatened use of deadly force.
Okay, it says, however, the use or threatened use of deadly force is not justified if you find that the defendant used force or the threat of force to initially provoke the use or threatened use of force against himself. So the standard language now includes a language that was omitted from Gibbs. So Gibbs really doesn't help the defense on this point.
What instruction is that?
This is, it's under 3.6H, no, 3.6F, on the, here's what if you're looking at, mine is page J-25. However, the paragraph starts with, it's on the top of that page. Your Honor, with regard to the Martinez case was not pointedly addressing the initial aggressor statute. It was addressing the forcible felony exception to self-defense, and that has not been requested by either party. So the only thing that Martinez does, it talks about the need to ensure that subsection 2, meaning the initial provoker statute, needs to be able to be enforced. And the way they were instructing the jury in the Martinez case prevented the jury from having any meaningful attempt, a meaningful opportunity to consider the initial aggressor part of the statute. So Martinez is at the very most dicta and doesn't apply to what we're talking about here.
And our position is that there's no evidence whatsoever that he used force or the threat of force to initially provoke the use of force against himself. None of the acts that are complained of constitute the use of force or the threat of force.
Well, I think the jury, if by listening to the tapes, could reach the conclusion that it was the threatened use of force by the totality of the circumstances. I think it's important to put the language, however, the use of deadly force or threat.
Yes, sir.
The use or threatened use of deadly force is not justified if you find that Nouman Raja used force or threat of force to initially provoke the use or threatened use of force against himself. That's, I believe, the standard.
And that's the standard.
Yes, sir.
That's a standard instruction. So I'm going to read the standard instruction with that correction, that addition.
We'll make the amendment, sir.
Okay? So the rest of it is standard, right? You have to take into the physical,
Yes, sir.
relative physical abilities and capacities, right?
Yes, and we have asked that the court substitute should, must for should here.
Not standard. And obviously, we object to that.
The standard says should.
I'll stick with the standard. And then what?
We have the same objection
Okay.
here on the last paragraph. Should put must. We request that must be there instead of should.
All right. I overrule that. Now, this is added on the bottom here. That shouldn't be there, right?
That could be a separate page.
Yeah.
It would be okay.
Page, right. Right. Now we get to manslaughter. Right.
All right, so the manslaughter instruction, gentlemen, on this side, is this the standard instruction?
Well,
It's all right, it's all right.
the issue is, which are they going under both theories?
We'll go under culpable negligence, Your Honor. So then 2 would be just B, but we're obviously won't have 2B. Because you have 2, the death of Corey Jones is caused by the culpable negligence of Nouman Raja.
That's their election, that's their election.
And guys, if you're gonna say you gotta do a lot of reading, can we take out the middle name?
Yes,
Yes, sir.
All right, thanks.
everywhere.
Everywhere. It just makes it easier for me.
Sure.
And the rest of it?
It appears to be the standard.
We would take out, obviously, we're taking out the act part here. So in order to convict a manslaughter by act, we'd take that out.
Thank you.
Yes, sir.
And culpable negligence is defined?
Correctly.
I'm sorry?
Just, just come up a little closer. Point to me. Are you on the manslaughter instruction?
Yeah, this
Okay.
sentence right here. Did you want that in there or no?
That's a part of the instruction.
You must have uttered this, that's-
I didn't know if they were proceeding with just, sorry.
No, it's okay.
The
No,
negligence. Okay.
everybody's on the same agreement. That's the standard.
Yes, sir.
The language is the same.
Yes.
No, thanks, Brooke. No problem. No,
1 second.
you've been a great help. Thank you.
So we're talking about the negligent act of commission? Yeah.
Just want to make sure everybody's happy with that language. It's a standard.
Yes, sir.
All right. Now, culpable negligence, standard.
And just so you know, we did add the firearm language, obviously, at the end.
You're back on the other one.
Yes, sir, just, that's the firearm language to say that it's, if he
Alright.
carried it, then it's manslaughter while armed.
All right.
Yep. Culpable negligence, yes, standard.
Attempt to commit a crime.
We had objected to reading attempted, this is attempted first crime. So it's attempted first, this is the standard for attempted first degree.
All right. Everybody's satisfied?
Yes, sir.
Done. Then the instruction for count 2, attempted murder, first degree.
I'm sorry.
No problem.
We go back to attempted commit crime.
This is just attempt to commit crime. That's the standard instruction for attempt to commit crime.
Understood. Now, but it talks about defending, abandoning his attempt, renunciation, abandoning. Is that, I mean, I know it's a standard,
But that wouldn't be appropriate here.
I mean, it's their defense, so if they're saying that they don't want it,
That's what I'm saying. You
Yeah.
don't want it?
No.
Starting with the word what?
It is
You want the first paragraph out,
You want the entire,
or you want the whole thing out?
Take the whole thing out, I just don't think it pertains.
The whole first paragraph?
No,
The
they want the
entire-
whole instruction out. It's a defense. It starts off with,
correct. Yep, I mean, if they want it out. Yeah, anything? Adrian?
Fine.
So that's out?
And for the record, Mr. Raj is here, listening to everything, he can lean over to his attorneys, and just for the record purposes, okay, that's out. And attempted murder, first degree.
Standard,
Okay, thank you. And attempted second degree murder.
which we objected to it being read, but as here,
Mhm.
it is the same.
All right, thank you.
Then we would add aggravated assault with a firearm and also simple assault.
You take the middle name out?
Yes, please, all the way through, just less for me to read. So ag assault, firearm,
Yes, sir?
and then just assault.
We actually, what we can do is we'll put ag assault and say previously, as previously read. Because you
As long as
previously,
there's no objection.
I'm sorry, say that again?
Where was it previously read?
forcible felony. Didn't we,
We did
I
a
think,
justifiable use
Yeah.
of deadly force.
Let's
We
make it
defined
easy.
there.
You want me to read it?
yes.
I'll read it.
Yes,
Just
sir.
put it in
Ag
there.
assault, firearm, assault.
Make
You
it
got
simple. And then do we get back to the easy stuff?
We did, I have assault in mind as well.
Yes,
Okay, so we, okay.
I'll do ag assault and assault. And I'll read the entire, just put the whole thing in there. Then plea or not guilty, standard. Weighing the evidence. Just check, we eliminated one, I can't.
Number
remember.
9, we eliminated, yes, sir.
And is there anything else that should come out? I don't think so. All right. Somebody highlighted something here. He's not become a witness in the case.
Correct.
And then there should be defendant not testifying.
Well, we had use transcripts
Now,
was prior, but wherever you want it, of course, Your Honor.
where do you want it?
That's fine.
Right there? Make it easy for me. Defendant not testifying, standard. Defendant's statements, that would still apply because of the rules for deliberation is standard. Cautionary instruction,
I believe there's another indictment in here somewhere, wasn't there?
information, you corrected that one.
Well, wait a minute.
Take your time.
Under the plea of not guilty reasons that burden of proof was information inserted for indictment.
Let's make sure.
No.
That was the other place it was.
That's, yes.
Take that. Right here.
No.
I brought it back to life. Right. So we got the indictment taken out of
Yes,
all
sir.
that, verdict.
Your Honor,
Did I skip one?
no,
Nope.
you didn't, I did. Once again, wherever.
We're back to plea and not guilty.
Yes, sir. Wherever the word should is in the last sentence, second to last sentence there, we would ask the word must be inserted instead of should.
And that's the,
Overrule,
Got it?
thank you.
just the standard.
Right.
Cautionary verdict.
Rules for deliberation, under paragraph 5, did we take out?
Back to rules.
I took out the murder, yes.
Okay, so it should just be that sentence.
It's the standard.
It is solely the judge's job to determine.
It
proper
is
sentence.
the judge's job to
It is
determine
solely
it.
the judge's job, right.
Then,
You're doesn't say saying- solely.
it doesn't say solely, it says,
What is the standard?
I actually read it, I added it there. It's my job to determine a proper sentence if the defendant is found guilty. That's how I read it. Any problem with it, guys?
it is just.
It sounds stupid for the judge to say, it's the judge's job. It's my job.
It is the judge's job, it's not solely, but however you want to do it, add,
Just standard, leave it.
Yes,
And I
sir.
just ad-libbed right there.
good to go.
Okay. Single defendant, multiple counts.
Is information in there?
Oh,
done
good,
this.
good catch.
Sometimes I listen to sometimes.
Got it that time.
It's actually different font, too.
Yeah, it happens. Submitting the case to the jury. Yeah. All right, now let's take a look at the verdict form. I guess it's not the right verdict form because we don't have all the lessers.
Correct, so we'll have, one is correct. Man while armed with a firearm, man, culpable negligence, not guilty. 2, we've got attempted first, firearm qualifiers, attempted second, firearm qualifiers, and then we'll add ag assault. With firearm, simple assault. Good?
Yes. That'll be our charge conference. I just asked y'all to make the corrections, email them over to the defense, because sometimes when you guys pick over a little, you pick something up that was not corrected, because tomorrow morning, we really want to have all the packets made, ready to put on the chairs and move forward. You need a minute to confer. Go ahead.
Expectation be by 5 o'clock today, sir, that we should have it done. It's not a whole lot to change around.
Judge, I just wanted to, just for the record, just read the objection on the provocation argument, in that the reading of that instruction, in some ways, may confuse the jury of delineating between the culpable felony required to revoke that versus the felony that they're charging him.
All right, noted for the record.
So, what happens now? State makes the corrections?
State's gonna make the corrections, they'll email a copy over to you guys around 5 o'clock today or sooner, I hope. You guys really look it over. I presume you guys have each other's cell phone numbers. The only thing I'm trying to make sure that happens is that tomorrow morning at 8 o'clock, we're not still shuffling papers. I know it's hard, routinely, as I'm reading, we catch a typo or something. And then I just tell the jury, take your pen, scratch through that, write this in, just so we keep things moving. But if you guys can just look through it, so it's minimized.
And who makes the copy?
They're gonna make the copies. And I think we decided on 15, is that right? So 10 jurors, okay, 1 for me, 1 for my clerk. I'll give you my copy when I'm done. Is that all right? So that's 12. How many do you need? 2? 3? That's 15. How many do you need for yourselves?
3.
And I bet you Madam Court Reporter would appreciate a copy as well because I read.
She says she doesn't need it.
She says she doesn't need one?
After the fact, she says that's when she's gonna get it.
All right.
scratch out 20.
We'll see. I'll have the last laugh on that. So it's not you tomorrow. Anything else?
No, sir.
See you all in the morning. Thank you for working so hard.
Thank you, Judge.